So, Max, should I blow in a Maryland DUI case? It's a question I get a lot, and the answer may have gotten a lot more simple. So, this video is going to talk about whether or not to provide a breath sample in a Maryland DUI case. I'm going to start by saying I always advise that if you're not on drugs and you haven't had anything to drink, you should give a breath sample because it's going to exonerate you. But chances are, if you're watching this video, you really want to know if the answer is should you blow or not if you've been drinking. So let's focus on that, because if you haven't been drinking and you haven't done any drugs, then provide all the breath samples you want, they'll all be 0-0. Let's talk about the two different kinds of breath samples we see. First of all, we got the preliminary breath test, and on the other hand, we have the breathalyzer intox ECIR test. The preliminary breath test analysis here is pretty simple. It's a roadside test. Officer gives you that little thing with the straw on it. It's not admissible in court. They're not all that accurate, and it really only exists to give the officer an idea of whether or not to arrest you. And the fact is that if you provide an alcohol sample on that, even if you're under the limit, chances are you'll still be arrested by the officer. So very little value, not a lot of reasons to provide a preliminary breath test here. So the answer is really no. Should you give a breathalyzer at the station? Okay, this used to be a little bit more complicated because there were some additional ability here to avoid the ignition interlock program if you were over 0.08 but under 0.15. So an attorney might have hedged and said if we had too much, you might have a better time with the MVA if you provide a breath sample. But effective October 1st, 2024, everything is going to change. And most attorneys will advise you that if you've been drinking, there really is not much of a reason to provide a breath sample. Let's talk about the changes first. Effective October 1, 2024, everybody who's convicted or even receives probation before judgment will have to do ignition interlock for some period of time. What that means is there's no way to avoid it anymore, so there really isn't much of a reason to give a breath sample with the goal of qualifying for a work-restricted license. So, even if you're going to blow under 0.15, but if you think you might be close to, below, or above the limit, there isn't much of a reason to blow. Let's go through some of the reasons why you might not want to give a breath sample here in Maryland. First and foremost, you might change the nature of the case, okay? If you blow over 0.08, you could be charged with driving under the influence of alcohol per se. What that means is if you have a BAC of over 0.08, the state's case goes from talking about your balance and trying to argue that there was alcohol in your system to just saying, well, he was driving and he was over 0.08. A lot easier to prove that than a case with a refusal. So in a case like that, the state has to prove beyond a reasonable doubt that a person was driving or attempting to drive, and that while driving, their normal motor coordination, balancing, things like that, were affected by the consumption of alcohol. And the degree to which it was affected means a difference between driving while impaired, the lesser offense, driving under the influence. We've got a significant impact on that offense. So you are essentially changing the nature of your case if you blow. You're also establishing the presence of alcohol in your system. So like I told you a moment ago, the state has to prove that alcohol is in your system and affected your normal coordination for a DUI and DWI charge. If you blow, well, it's pretty solid evidence there's alcohol in your system. A lot of people ask me, but Max, what if I'm under the limit? Well, many people don't know this, but a 0.07 means that there's an inference that you were actually impaired. So even blowing under the limit can have a similarly negative impact. You can be prosecuted for a DUI for a 0.02 or a 0.03. In those cases, there might be an inference you were not impaired, but again, by blowing, you've actually put the alcohol in your system. So in some ways, even an under the limit blow can do more damage than good, depending on how far under the limit we're talking about. But Max, if I refuse, the state, they can argue I only refused because I was drinking. Sure, they can argue that. But isn't that a weaker argument than holding up the test result? You better believe it is. The jury instructions here in Maryland will allow your attorney to argue there are other reasons why you might have refused, or in fact, you might not have even refused at all. That's a factual argument that your attorney can make, and there's a specific jury instruction for a refusal of a breath or blood sample. So, in sum, by watching this video, I hope you gain the following. If you've not drank and you've not done any drugs, there exists no reason not to blow. But if you believe that your breath sample might incriminate you, in Maryland here we've changed the law, or we're going to change a law, in such a way that there is a very diminishing value in giving a breath sample. So take with it what you will. I think the blanket advice will change from it depends to don't blow. Good luck out there.